Hello everyone, I'm Tim Salen with PDX Real Estate Team. Today we have a special segment that I believe will be invaluable for both first-time homebuyers and seasoned investors alike, and fellow realtors. So navigating the world of real estate can sometimes feel like deciphering a foreign language. One of the terms you might have heard is title company. But what do they exactly do? Why are they even pivotal in the real estate transaction process? To shed light on those questions, I'm joined by Shana Jackson from Stewart Title. Shana has been in the industry for 21 years, helping countless buyers and sellers ensure their transactions are seamless and free from unexpected title surprises. So welcome, Shana. We're thrilled to have you here with us here today.
Thank you. I'm happy to be here.
So I just want to ask you some of the most common questions that I get when I'm out there with home buyers, and they're trying to figure out what it is. Why is the title company involved here? So one of the first things is the role and importance of a title company. So what exactly does a title company do in the home buying and selling process?
Well, we are a neutral third party that is there to ensure everybody's interest is represented in the transaction. We hold the money, we hold the documents, and we make sure that the buyers get clear title to the property once the transaction closes.
Okay, clear title.
Clear title, meaning that there's no liens or judgments against the property or the sellers that also would attach to the property when the property transfers over to the buyers.
Okay, so that makes sense. So title search, a lot of people saying that there's title searches being done. Can you explain what a title search is and why it's necessary?
Absolutely. We search many, many things. We search the county records for documents that have been recorded that may possibly put a lien or some sort of encumbrance on the property, say an easement allowing somebody else access to the property, which could just be something as simple as power lines or sewer easement, or it could allow your neighbors access to their property crossing your property. Those are all documents that we would disclose. It could also find a lien on the property, say for an unpaid loan or property taxes or some other sort of judgment that's out there that could be involved in the seller or the property owner. It would also tell us of any possible upcoming interest of a homeowners association. Just simple things like that.
So anything that's been recorded against property.
Yes.
So title defects. What are title defects and how do they affect the transaction?
Well, title defects could be things like covenants, conditions, and restrictions, which are things that are recorded typically in a neighborhood that a lot of times has a homeowners association, and they do affect your usage of the property. They can be something as simple as you can't have a 10-foot fence in front of your property, or something as crazy as you can't have more than 3 pigs. It just kind of depends on how long ago it was recorded. Those are some of the crazy things we find.
So sometimes I've seen in the past in the CCNRs, covenants, codes, and restrictions, some people call them different things, is like, for example, that you have to have a shake roof, but you look around and other people have composite roofs. How is that?
So city codes can override the recorded CCNRs. So if your city comes in and puts in a code that doesn't allow shake roofs anymore or allows you to go to a composite roof, that would actually override those CCNRs. So if you go down to the city to get a permit to put a new roof on, they'll tell you what you can actually do. Or if you have an association, the homeowners association can override those recorded CCNRs too and give you permission to change that.
So I've also noticed in the preliminary title report that's put out there with the CCNRs, there's sometimes things that negatively affect the title that don't necessarily apply because they're not legal anymore. For example, I had a client buy a house in, let's just say it was Milwaukee, and it had in the covenants, codes, and restrictions recorded saying that no non-Caucasian person can reside in the house unless they're a maidservant or manservant. Now, explain how that is bypassed now.
Again, that is also part of statutes that have been put in place by cities and states that overrule those recorded CCNRs. The only way to get rid of a recorded CCNR would be to record an amendment to it. And a lot of people don't want to hire the attorneys and deal with that, so they just fall back on the state and city guidelines that overrule those.
Yeah, because usually that's for a development of 60 years ago, 100 years ago, and you're not going to get all the homeowners now wanting to buy that cost of changing those. So if something is recorded on title, it sounds like it stays there for eternity until it's removed somehow or another, or overridden by federal or state law and county regulations.
Correct.
Yes. Okay. So title insurance. So what is title insurance and why is it important?
So title insurance for a buyer is purchased by the seller. And when we do that search and put that title report out, if we find any liens, say the seller has a loan that we're going to pay off at closing, we are ensuring the buyer that that lien won't affect their ownership of the property. So title insurance actually goes backwards from the day of recording the deed to transfer title from the seller to the buyer. And it ensures that the buyer gets the property free of any liens or judgments from the previous owners.
Okay. So then why am I as a buyer having to pay title insurance also?
So the buyer would purchase title insurance for a lender if they have one, ensuring that the lender gets first lien position on the property. So we also search every individual person involved in the transaction to find out if they have any judgments against them personally, say a child support or spousal support judgment. And we have to make sure that's current to make sure the lender gets first lien position.
Yes.
Yeah.
And you do want to make sure that you check or divulge all this, because I heard a story, not one of my clients once, where they get all the way to the closing table and they find out that there is a lien against the now husband for child support for a child that the wife never knew existed. So that house may not have closed. I'm not sure. I didn't follow up on that.
And did you know that in Oregon, a support judgment stays active for 20 years past the last payment date unless it's actually satisfied?
Make sure you pay your child support. You should be doing it anyway. But anyway, closing costs. What portion of closing costs are related to title work and insurance?
Well, there are a few that are related to us, one being the escrow fee, which is typically split between the buyer and seller. The seller would purchase the buyer's title insurance, and then the buyer would purchase the lender's title insurance. And then typically the buyers pay for the recording fees. And if a notary is needed, then that party would pay for their own notary service. And Washington County does charge a transfer tax, and that is typically split between the buyer and seller. Title and escrow does not have a numerous amount of fees, but sometimes they can be a little bit higher because they are based on the sales price or the loan amount.
And every situation is a little bit different. So
exactly. Yeah.
Cool. So what role does the title company play in the escrow process?
So again, we aren't just that neutral third party. So we collect all the documents from all the parties that are involved in the transaction, and we do keep them securely. Only the buyer is allowed to buyer information, the seller allowed to seller information. We don't share. We do gather all of the money and make sure everything is where it needs to be before we release funds once we recorded the documents. We're kind of that little protector of everybody involved to make sure that everybody's interests are secure.
That's good. While you're working for both parties, you're not working specifically for one party. Yeah. So when earnest money is deposited into escrow versus into one of the brokerage's accounts, that earnest money cannot be released until both parties have signed off on who is requesting it back. Correct? Yeah. So you're protecting the earnest money there. Again, you're not... Just because I chose you as my title company doesn't mean that my buyer and or seller will get their earnest money back. It's still going to take both parties. So even though we have a relationship, there's no preference there because you are a third neutral party. Yeah. So the closing process, what does the closing process look like from the title company's perspective?
Well, once we do have everything we need in our transaction to transfer clear title to the buyers, then if there's a lender involved, we have to receive the loan documents from the lender, and they have their own underwriting process it has to go through. Once we have that, we have everybody come in and sign. The buyers submit their funds. The lender submits their funds. And then we can record the documents, first the deed to transfer title and then any loan documents. And then we send everybody their money and give them the good news.
That's right. So most of the delays, from what I'm understanding here, are usually in the loan process, the inspection process, everything else. Once things get to the title company, that is going fairly fast. I mean, as soon as you get docs, so long as there's a date, then it has to be set by and nobody's changing that. You can turn things around in 2 or 3 days.
Correct. Yeah. Once we have title clear, we pretty much just kind of hurry up and wait. And then we do a little bit of a sprint at the end. But it's kind of fun and challenging, and we enjoy it.
So when I'm purchasing a home, I can give you a personal check for the earnest money because it's a longer process, usually 30 to 45 days. But right before close, I'm going to put that other 20% down, or the rest of that 20% down. Can I give you a personal check for that?
If you give it to me at least 10 business days prior to recording.
What is the preferred method of receiving it? Why?
Sure. There actually is an Oregon statute that regulates our closing funds, and we have to have a cashier's check a minimum of 1 business day prior to closing or recording, and we can accept a wire the same day.
Okay. So cashier's check 1 day before it's due to fund and record, or a wire the morning of, I'm going to assume, the day it's due to fund and record. So that's the differences. Yeah. And be careful when you're wiring money too, because there is a lot of fraud out there.
Yeah.
I always tell my clients to go back to the first email that you've received from the title company, not the one who's requesting you to wire funds here. Go to the first email, call that person up and say, did you send me this?
Yes.
Not the one that you're getting then.
And if you ever get an email from somebody that says, our wire instructions changed, you need to wire funds now, please don't.
There's a lot of fraud out there.
There's a lot of fraud out there.
So what are some of the common issues you encounter, and how are they resolved?
Well, a big issue that we have is judgments for support in trying to get the ex to sign the satisfaction so we can close. And then the second biggest issue we have is homeowners associations. A lot of them now charge to send the documents we need for closing, and a lot of them take a long time to get those to us, so it can cause a delay. And then this time of year, in the October, November, is waiting for the county to send out the new tax numbers.
Why? No, what to check?
Yeah, all the counties' websites are down right now, so we can't even see what the taxes were last year. So it's another hurry up and wait situation. We're usually about a week where we can't give out information, and it's frustrating for everybody involved.
Yeah. And one of the reasons that people should get information to you immediately, because upon opening escrow with you for a purchase and or sale, you're going to be doing a request of information from them. So I know you experienced this with one of mine, where the homeowners had paid off this equity line of credit years ago, but it was still showing on title. So it'll take time to get that proof from that old U.S. bank company to get that proof to show that it was paid off years ago. Otherwise, you could not close until you had proof of this, right?
Yes. Yes, exactly, because that would be transferring title to the buyers without clear title. Yeah.
We want clear title. Clear title means that the buyer can turn around the next day and sell the house if they wanted to, with no liens except their own, or nothing else on title except what they put on title themselves. Yes. So documents. What documents should buyers and sellers bring to closing?
When they actually come in to close, the sellers will need to bring in their photo ID, driver's license, passport, some sort of state-issued ID, and they will need to bring how they want to receive their funds when they're available. We can wire to them. We need full bank account information, or we can just simply cut them a check out of our escrow trust account, and it's totally up to them. Buyers will, again, also need to bring a photo ID, and then their closing funds. If they're bringing a cashier's check 1 day prior to closing, or we can hand them when they come in to sign the wire instructions so they know they're valid, and then they can wire their funds to us. But the day of closing, not a whole lot is required for people to bring in with them.
Cool. Yeah. A lot of times nowadays we're hearing a lot about FIRPTA. Can you explain what FIRPTA is to us? Because I think both the agents and the title company and lender, everybody's trying to figure out if this person is a born investor or not. Can you tell us what you do to ensure that it's not a born investor?
So
or what FIRPTA is even.
Right. So FIRPTA is the Foreign Investment in Real Property Act, and it is to ensure that parties that are not legally in the United States are not selling property and not paying taxes on it. So if you are here and you have a Social Security number and you're paying taxes, income taxes, etc., you're filing a tax return, FIRPTA is not going to apply. That tax is not going to have to be paid. But if you say we're here on a work visa and you bought property, your work visa expired and you went back to your country and now you've decided to sell that property, you are a foreign investor in real property and you will have to pay that FIRPTA tax. They can apply for an exemption. It does take a while to receive that. We've had several situations where that's happened, and in that case, we actually hold the 20% in our file until we receive the exemption confirmation from the IRS. That can take up to 9 months to receive.
So you are probably the most involved, title company is most involved in making sure that this person is not a born investor, because if by chance, and this probably happened around the boom of 2004 through 2008, if by chance a property is transferring between two people and that person was a born investor and it wasn't verified, who's responsible for those taxes to the federal and state governments?
Well, the tax law actually says the buyer is. Because the seller's already out of the country, they're gone, there's no way to find them. Yeah, so it is in the buyer's best interest to make sure that FIRPTA is checked.
Yeah.
Yes.
Yeah. So just having all that documentation helps protect them.
Yes.
So one of the last questions that I have for you is how to take title. A lot of people wonder, how should I take title? Okay, you're a married couple, should I take it this way or the other way? Can you give us a couple of the most common reasons to take title a certain way?
Yes. Well, Oregon is not a community property state. So if you have two parties in title and there is not a vesting specified and something happens to one of those two parties, a probate will have to be done on that property for the other party to be able to do anything with it. So typically, if you have a couple that's married, they will take title as tenants by the entirety, and that gives them a survivorship estate. So therefore, if one party passes away, the other party just records the death certificate and they remain the sole owner in the property. The other option would be as tenants in common, which would give each party a 50% ownership in the property unless they specify a different ownership percentage. And that would leave the party that passes away their percentage of the property to their direct heirs. So maybe their children or somebody else they've specified in a will or something. If the party's not legally married, they could hold title not as tenants in common, but with rights of survivorship, which would again give them that survivorship estate. Those are the three options we see most common. There are many other options, and if you're not 100% sure, the best thing to do is talk to an estate attorney, because there can be tax implications in the different ways you hold title, so you don't want to have a tax issue down the road.
And you're normally asking the clients when they're in front of you, again, what type of title they want. So
we send out a letter when we open title to the buyers, asking them the most common options to choose one, and if one of them doesn't work, then to let us know that they're talking to their attorney. Yeah.
Well, perfect.
Yeah, because the lender needs that information as well.
Yeah.
Yeah.
Well, thank you very much. Hopefully we were able to answer some of the questions that are most common out there and probably most unanswered questions about what title's responsibilities are in a real estate transaction. So, Shana, it was awesome to have you here today. I appreciate your time and thank you very much.
Thank you very much. It's fun.